This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why if you do the tort, you must pay the damages and you get no indemnity from a third party for your own sole negligence. And that is what happened when the city of Kansas City, Missouri, sought contractual indemnity against a company called Occupational Health Centers of the Southwest, doing business as Concentra Medical Centers in the Circuit Court of Jackson County, only to be refused by the trial court. In a case called the City of Kansas City versus Concentra, the Court of Appeals of Missouri, the Western District, 3rd Division, on September 12, 2023, dealt with the city's indemnity claim, which sought to shift to Concentra the costs associated with an employment discrimination claim which had been asserted against the city. The Circuit Court granted a summary judgment to Concentra, and the city appealed. In 2012, the City and Concentra executed a contract for the performance of drug and alcohol testing on city employees. The city sent Shahidah Hazziez, a city employee, to a Concentra facility for purportedly random drug screening. Hazziez later contended that she and other Muslim city employees had been disproportionately selected for such drug testing. Concentra notified the city that Hazziez had refused to provide a compliant urine sample and had claimed it was due to a bladder infection. After Hazziez was fired because of the failure of the test, she sued the city as well as a number of Concentra-affiliated entities and employees. Hazziez settled her claims against the Concentra defendants. Thereafter, a jury trial began against the city and defendants other than the city, who later settled while the trial proceeded. After an 8-day trial, Hazziez asked the jury for damages because the city had discriminated against her. The only adverse employment action Hazziez identified was the termination of her employment with the city. The jury found in Hazziez's favor and against the city on Hazziez's claim for discrimination based on sex and a perceived disability. The jury awarded her compensatory damages of $172,000, but found that the city was not liable for punitive damages. The court subsequently awarded Hazziez attorney's fees in the amount of $303,660 and costs of $10,130.85. The Court of Appeal affirmed the judgment on appeal and also awarded Hazziez her attorney's fees on appeal, which were later determined to be an additional $88,896. The city satisfied the judgment in November of 2020, and then filed a third-party petition against Concentra for indemnification under Concentra's contract for drug and alcohol testing services. The Circuit Court entered its judgment on July 29, 2022, granting Concentra's motion for summary judgment and denying the city's cross-motion. Ultimately, the Circuit Court concluded that Hazziez's claim against the city were not based in whole or in part on Concentra's actions, but that the city's liability to her was based on its own actions, for which Concentra had no indemnification obligation. The Court of Appeal focused on the plain and ordinary meaning of the contract itself and did not look to extrinsic evidence unless the terms of the contract were ambiguous. The city was held liable for its own actions. The claims for which the city was held liable did not arise out of or result from acts or omissions caused in whole or in part by Concentra. Concentra was required only to indemnify the city for liability arising from Concentra's actions, but not liability resulting from the city's own conduct. Because the city's liability to Hazziez arose solely from its own actions, not in whole or in part from Concentra's actions, the Circuit Court properly granted summary judgment to Concentra on the city's contractual indemnity claim. In my opinion, insurance is designed to protect an insured for damages resulting from its negligence. Indemnity agreements, like that in the city's contract with Concentra, even if covered by Concentra's own insurance, is designed only to provide indemnity if the city was held liable for the actions of Concentra, the indemnitor, since only the acts of the city caused damages to Hazziez. It had no right to indemnity from Concentra and could only be indemnified by its own insurance. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog at the blog itself, and it's free, and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and have access to all 4,600 plus blog postings. You can also subscribe to the videos at YouTube and or rumble.com. And if you do, I'd appreciate you clicking on the like button on YouTube and the thumbs up button on rumble.com. And please, it's free. Subscribe to both YouTube and rumble.com. And if you found these videos to be useful to you, please tell your friends and colleagues about the blog and the videos and let them also subscribe. And if you wish additional information about insurance, insurance claims, insurance fraud, or insurance law, please consider, for a very small fee, subscribing to my Substack publications or my locals community. Thank you for your attention.